But I find, though, too, that lawyer involvement is tremendously valuable. Some of the issues often can be finding out what data harvesting company is involved. You get a disclosure from an employer, trying to figure out what company they will be using to run their background checks, and then to preemptively contact that company, but also, too, to find contact information for these people. Don't make it easy to find them and to contact them with some sort of live number. I have some addresses for some of the data harvesting companies that are around. Again, I'm happy to share any information. But sometimes just getting a hold of somebody can be the big challenge. Like I said, I find that when I contact them, if I send them a formal letter, most of them are really good about this. They know that a lawyer's involved. They really don't want to mess with it. If it's something that's been expunged, a lot of them have their own internal policies that they just won't go there. And so I've found it to be an effective form of relief to try to preemptively stop a data harvesting company from reporting information. It's at least worth a shot. So as we mentioned, the Fair Credit Reporting Act allows consumers to contest the contents of their reports. That, too, is something that I highly advocate, especially since it's after the fact, the cat's out of the bag, so to speak. And then the other thing, too, is a lot of times these credit reporting agencies, these data harvesters, they will play ball, so to speak. They will not report the information, but they want some sort of concrete proof that this has in fact been expunged. I've had credit reporting agencies, data harvesters, ask me to send them copies of court orders, asking to see that something has been expunged or the conviction's been set aside or whatever it may be. I oftentimes will do that since we're already talking about the offense itself and they know about it. But a lot of times they just want some sort of definitive proof or court documentation. So that's another service that I can provide to my clients in helping them navigate that process and obtaining those records for them, because a lot of times they don't know where to find them. Records that have been expunged, sometimes it can be very, very difficult to obtain that information. I might need a court order or some type of other special permission in order to now get back into that sealed record. So I help clients a lot of times with that aspect of this as well. So FCRA remedies. Somebody's in violation of the Fair Credit Reporting Act. Number one, there's no injunctive relief. So you can't necessarily mandate that somebody's going to stop it. But willful or knowing noncompliance. Again, a lot of times this comes down to them reporting information in a knowing fashion or mistakenly reporting information and not knowing that something has been expunged. So there's actual damages. If it's willful, for example, there can be, even if there are no actual damages, let's say the person gets the job anyway, there's still a cause of action there. It can be $100 to $1,000 in relief for someone. Punitive damages, and then attorney's fees and costs. Even if it's negligent noncompliance, perhaps the company reported old information and did not get updated records, did not realize that something has since been expunged, there's still damages that are there, albeit you usually have to demonstrate some type of actual damage in order to prevail on that. Fair Credit Reporting Act remedies, some of these can be sizable. I know that you look at the numbers and you go, okay, $1,000, this doesn't sound like a very lucrative thing. But if there can be issues with regard to class actions, there can be issues with regard to repeated violations. I gave an example of a case here, Hunter versus First Transit. It was in the Eastern District of Illinois from 2012. It was a $6 million settlement against an employer for these issues of violating the Fair Credit Reporting Act. And again, that was on the employer side of them not giving proper authorization or getting proper authorization, not giving a proper disclosure. But so there can be some real issues here that crop up. And again, I know a lawyer who practices in this area. She's very good, and she has made a career of going after people to try to get them in compliance, employers. So I talked a little bit about, shifting now a little bit to the Title VII, the Civil Rights Act of 1964, and how there's also a layer of protection here, albeit it's not as strong as the Fair Credit Reporting Act. So Title VII essentially says, it talks about disparate impact claims. So a party can demonstrate, if they can demonstrate, that a particular hiring practice causes a disparate impact on some sort of protected class. There's a problem there. And so the respondent employer has to demonstrate that the challenge practice is job-related for the position in question and consistent with the business necessity. So they have to demonstrate, if you're an employer, you have to demonstrate that whatever requirements you have of saying, no theft offenses or, whatever, no felonies or whatever it may be, you're far better served to show that A, that that's a necessity for the employment position itself, but also too, there should be some checking to make sure that this isn't going to naturally exclude people of a certain protected class. These claims are very, very difficult to prove because you not only have to get a hold of what the hiring practice is, what the job duties are, but then you have to get data on how many people are applying, how many people are being excluded. It can be a very, very difficult process to prove one of these claims. So that said, though, there are cases out there. So Pepsi in Minnesota settled with the Equal Employment Opportunity Commission for $3.13 million. Job applicants who had been arrested pending prosecution, who were not hired for a permanent job if they've never been convicted of an offense. So people who essentially had an arrest record and were not convicted of that offense were generally not hired by Pepsi. And it was found that this process excluded more than 300 African Americans in particular, who obviously have higher rates of being stopped by the police. This is a very hot button issue right now. I don't want to go into all the issues with that, but I think the numbers, I think people can generally agree that African Americans in particular are stopped at higher rates by the police. And here's an example of where that particular criteria, that particular exclusion, can end up impacting a particular protected class. So investigating disparate impact, as I mentioned, is very difficult. You have to determine first the policy or practice that causes the disparate impact. You have to gather information about how it was actually implemented. So was it actually used, or were people routinely disregarding it in hiring practices? Which offenses were reported actually to the employer? Was the information the employer was getting accurate? Did they use it? Whether the convictions, including sealed or expunged records, arrest, charges, how far back the reports go, how relevant it was for the particular job that this employer was offering or hiring for. To determine the disparate impact, the data on who's applying for these jobs, national and local data regarding arrest numbers by race are assessed, as well as race or a protected class, as well as an employer's applicant pool, the employer's reputation in the community, other evidence. There's just a lot of subjective, sometimes very difficult to access information and statistics that goes into making one of these claims.